Okay, good afternoon everyone and welcome to this public meeting of the Standing Committee of Tynwald on the Constitutional, Legal Affairs and Justice Committee. I'm Tanya August Phillips, MLC, and I chair this committee, and with me is Mr. Stuart Peters, MHK, and also the clerk to Tynwald and also clerk to this committee, Dr. Jonathan King. Before we begin, let's just make sure that mobile phones are off or on silent. I have to say it, sorry. And today we're welcoming His Majesty's Attorney General, Mr. Walter Wannenberg, and also Nicola Pitts and Chrissy Hunt. For the benefit of Hansard, would you please introduce yourself, including your title, how long you've been in post, and if Mr. Attorney General perhaps provides some form of examination of perhaps over the last year or so of chambers and activities at chambers and where things have changed, where they've not, and any other additional information that he'd like to provide. Thank you.
Thank you, Madam Chair. My name is Walter Wannenberg. I'm the Attorney General. I've been in post since October 2022. I'll let my colleagues introduce themselves.
I'm Nicola Pitts. I'm the Executive Director of Legal Services for the Attorney General's Chambers. I've been in post nearly 18 months, although I have been a legal practitioner in Chambers for 10 years now.
And finally, I'm Chrissy Hunt. I'm the Director of Prosecutions, and I've been in post since 2019.
Thank you very much. So, Mr. Attorney General, do you have anything that you'd like to say before we get started?
Well, I think you gave me a broad invitation to talk about the past year, and it's been a busy year, one I think which has seen us build upon the legacy of my predecessor. You will be familiar with, it's perhaps been an unusual year in as much as there have been a number of reports concerning chambers, either directly or indirectly, and so I mentioned briefly the Wooler report, which was debated in Tynwald, I think, last year, and then the Richard Wright report concerning a particular case and the way in which litigation is managed in chambers, and then finally, but no less importantly, is the Garnier report into legal services on the island generally, and I half expect that you will be asking me to talk perhaps about some of the recommendations made respectively in those reports, and we are armed with that information. But other than that, I suppose the headlines from Chambers, apart from the most important headline, which is continuing business as usual, with some very important functions with which you will be familiar, and not least of all our prosecutions division, but also our children and families division, the registration of charities and the regulation of charities. And that's not to talk down the importance of any of the other innumerable functions carried out by my colleagues in chambers. We have seen some movement in staff, not least of all in our secondary legislation team, where pursuant to a common direction, you perhaps will remember that about 2 or 3 years ago there was a direction that all secondary drafters and what were referred to as policy officers should be centralised into chambers, and much more recently that has to some degree been reversed with the policy resource transferring out of chambers, and so I think we lost 5 officers in the last 6 months. Is that right?
5 officers plus 2 vacancies.
So that has reduced the headcount in chambers. But as I say, other than that, the divisions all remain fully recruited to. There has been development in prosecutions with the establishment of a financial crime arm to it, sourced or recruited from within. Chrissy has been good enough as well to take under her wing our ICART division, so that marries up quite nicely with her duties as Director of Prosecutions. But so far as the other divisions are concerned, there is nothing perhaps of too much note to draw to your attention. There is growth, certainly in charities and in financial management of persons who are incapable. But other than that, it's as I say, business as usual. I should also draw to your attention a lot of work which is being done by our business development or change manager in procuring, not yet done, but nearly done, a new case management system, which has been something which has been underway for very many months. And we're in the final stages of procurement and we'll be awarding the contract, I expect, in the first quarter of this year.
Excuse me a second, Chairman, I'm having trouble hearing. Just try a different setting.
Yes, I think that's perhaps wise.
Feel free to carry on.
No, we'll stop for a moment, not to worry. Right, so we last met in here on the 6th of February 2023. And since that, you've published your 23 to 26 business plan and your 2023 to 24 annual operating report. So thank you very much. Have you any feedback on the business plan and the operating report at all?
Personally, no. And I sometimes doubt how wide the readership of these reports are. But if I may, I'll ask Nicola to just respond. She's in a major way the author of those reports and closer to them, I think.
We had previous feedback that there was a lot of text and a lot of numbers, so we did, as part of our kind of rebranding project this year, look at how we were perceived by the public who would need to know what they need to know from looking at the operating report. So we did spend a significant amount of time on reformatting and looking at actually what we were there to deliver. So the operating report has been substantially reformatted, rebranded, and it now has a Chambers in Numbers section, so we kind of distilled down the numbers, and what we're looking at for the next period is to look at a publication scheme so that we can publish statistics in advance. So for example, Chrissy in her division has numerous statistics that they rely upon for day-to-day delivery of their functions. There is no reason why we can't be publishing those as we go along. A lot of that work at the moment is reliant on a new legal case management system, which, as Mr Attorney said, is due to come in shortly. In terms of feedback from the operating report, I haven't had anything formal, but we have had one or two comments. One particularly notable comment where a person new to government came in to meet with us and mentioned how user-friendly he found the format. It was short but to the point, and it gave him the information he needed to know as a service user before he came to the meeting with us. So at least some bits of valuable feedback there, but certainly nothing formal and nothing widespread, unfortunately.
Can I ask how long it takes to prepare these reports, Nicola?
At the moment, it varies. This year it took a lot longer because we substantially redrafted, so we pulled it apart and put it back together again, so I couldn't really give you an estimate of the number of hours. The hours will also depend on the statistics and other information being published, which at the moment are being prepared and published manually. And due to that manual publication of data, so as I said, using the example of Chrissy's division, all of their statistics are produced on a manual basis. They're put on spreadsheets, Word documents, and then collated into what you see before you now, which is a fully branded and formatted report. So there are a number of steps which we'd like to hope can be digitised in the future, not only from a management information reporting point of view, but preparation of and publication of statistics.
I always find it quite interesting that not just the Attorney General's Chamber, so I'm not picking on you, I promise, but the like in and around government, there tend to be an awful lot of reports, and you do wonder at some of the readership and whether or not people are actually consuming some of them and whether that time is well spent, but particularly in relation to like your own time, for example, Nicola, which is very, very highly valuable in the Attorney General's Chambers, I would imagine.
Yes, and we certainly had one eye on that. We knew this year would be a particularly tricky year. As I say, we were pulling the report, how it looked before, we were pulling it apart and putting it back together again. Now it is together. It follows substantially different format, but one that hopefully speaks to the strengths and weaknesses of each division that we can report on properly. So the focus now is very, very much just on what we're there to do, what we're there to deliver, and how we've delivered it. And if we, stick to those rough headings, which is what we've tried to do in the report, hopefully future year reporting won't be quite so arduous. And certainly with a new legal case management system, where some of that reporting and statistical information will be produced at the click of a button, which at the moment we either have seniors compiling that information and administrators supporting them. Some of that time should be replaced with digital information in the future.
Right, okay, thank you. Just going on to some of the statements that Mr Attorney General provided there. Staff performance you made mention of. I mean, obviously there's an awful lot going in and around government in relation to performance and performance measurement management. What's happening in the Attorney General space in relation to that?
So performance management wise, we have a senior leadership team and an extended leadership team which just meet regularly to ensure that we are on the same page, so to speak, in terms of how we performance manage. We have followed the government guidance and more, I would say, in that most of our divisions have more than the recommended level of one-to-ones, peer review meetings, team meetings, and each of the divisions is preparing or has already prepared a manual in terms of how the functions of their own division look, how they deliver their functions and how they want to deliver their functions. Coming from that, then we have performance appraisals. So we've just met as a senior leadership team to discuss year-end appraisals and going forward for the new year, so setting performance objectives in each division. So we start off with divisional objectives, as you might expect, and that links back to our operating report and business plan. What are we setting out to do? So once those divisional objectives are set, then each head of division, so Chrissy and her division, will then set individual performance objectives for each officer or each part of her team. Chrissy, I don't know if you want to give some examples of what you do in your division.
Certainly. So with a view to prosecutions being separated, we have developed, for when the case management system comes in, key performance indicators around for something like early guilty pleas, because the measure of a good case is how quickly somebody pleads guilty. That there will always be people who will not plead guilty till they get to the doors of a trial, and we accept that. But that's a measure of how key stakeholders are doing as well. Are the police providing good files? So we try and build that in, and certainly in relation to our business objectives, it's about the right person doing the right thing at the right time. It's about that right review taking place, and it's about adding grip and adding value to the review. It's not just a tick box exercise, so it's a real drill down into the case. So that's the majority of what the practitioners focus on in terms of their PDRs. So I set the objectives at the beginning of the year. We have a discussion about them. We then have other reviews throughout the course of the year. We have a mid-year review to make sure that office is on track, and then at the end of the year we'll look back at the performance and see that all of those objectives have been maintained and attained, and we move on to set the objectives for the following year.
Right, that's fantastic. And how often, I mean, that sounds quite comprehensive, so how often do you review what it is that you're doing in relation to performance management and ensuring that you're kind of like keeping up to date with, I suppose, what government are doing, but then also with like sort of best practice and benchmarking against other jurisdictions perhaps?
I think that we keep under regular review, and I would say not less than monthly review in terms of what we're doing for performance and appraisal monitoring internally. In terms of benchmarking wider than that, I'm not sure we've carried anything out in the last year.
No.
But we benchmark really against best practice from Isle of Man government policy. We start there, but often we try to go one further. So if you look at 3Cs conversations and having to have 4 per year, we'd routinely have 6 to 8 in each division. Certainly in my divisions, it's been a monthly meeting for one-to-ones and peer reviews as well.
Yeah. And what about, like, generally, Mr. Attorney? I know that there are conversations between the Attorney Generals in the various Crown dependencies.
Yeah.
Do you find like that's a useful way of benchmarking certain things between Attorney General's chambers in the Channel Islands and here on the Isle of Man?
Is yes, and I think our last meeting was in September. But I can say that on that occasion we didn't compare the way in which we appraise our staff, but there were innumerable other matters of common interest. The one which immediately springs to mind is the way in which those two jurisdictions prepared for their money evaluations I think 3 to 6 months prior to that meeting. So it was enormously helpful to share their experiences and bring it back into chambers by way of our own preparations.
Okay. Thank you. You also mentioned, Mr. Attorney, about the 5 officers and the I think there are 2 vacancies as well, the 5 officers that have moved out of chambers. Am I right? They've moved out of chambers, not that 5 officers are in chambers, but that they've moved out back into government departments to provide that policy input and the policy development work that goes into, I suppose, writing instructions, etc., and working on secondary legislation. Sorry, excuse me. But how many are actually still sat within chambers at the moment?
So we have 8 in the secondary legislation hub that just focuses solely on secondary legislation drafting. So they don't take any part in policy. They have produced, again, going back to the divisional manuals, they've produced a manual for their own division, which sets out their functions and the responsibilities of departments, instructing officers, and our primary drafting division as well.
Right, okay, so they still work quite closely together, I suppose, in the way that the previous Mr. Attorney envisioned.
Absolutely, yes.
Yeah, and that works quite well, does it?
It seems to work well for the best part. I think relationships were built, so and there's a greater understanding of policy and legislation on each side. I would say that coming with that is some churn, and you'll not be unfamiliar with the churn of policy officers across government. There is some churn, and we certainly saw that in chambers as well. And we do have a number of new recruits who, whilst don't have the drafting experience, are very keen, very willing and very able. And so we have put a lot of investment of time into the to settling that team in and ensuring that the appropriate training, whether that's on the job training or external training, is provided to them. And at the moment, it's a very settled and a division that is drafting a lot of legislation. I think it's in the operating report. I think just over 50% of all items on the order paper was drafted within that division. So it's a very busy division for the amount of resource that we have, and it's a cross-government service.
I mean, obviously, with that, not doing policy in the chambers, you kind of go back to sort of like a similar conversation, I suppose, about on balance what's going on in government, what's going on in chambers, and sort of is it providing the right throughput or flow of policy development stuff. So, say for example, drafting instructions and writing up instructions for primary legislation, and that are sufficient enough to go into the primary team with that policy input and that policy work. Are there enough of them sat in and across government to do that job versus, like, obviously the way that they sort of moved into chambers, I suppose, was from across government where they did the policy, and then they weren't supposed to be doing the policy, so we ended up with people that could write the secondary legislation but needed instructions to write that legislation because they couldn't do the policy work. So is it balancing out? Is there the right throughput, and are those conversations taking place between the AGC and also, I suppose, senior individuals sat within Cabinet Office and COG about whether or not that flow is sort of working from the start of policy principles into a piece of secondary legislation having been drafted, and that iterative process having been completed?
That is a topical question, or questions, and I think if you would speak to our drafters, the experience is that there isn't a sufficient policy resource pan-government to avoid what is commonly referred to as delays in instructions, and perhaps of more concern, is the quality of instructions which come in. So I'm bound to say that the officers who left Chambers to become a policy resource, and I'm not sure that is all they do. They're probably also drafting in departments, but there are issues with the quantity and quality of instructions, which I think reflects that the policy resource, as we call it, across government is not what it could be.
And those conversations take place between yourself and members of COG and also the Chief Executive Officer and Chief Operating Officer?
I can't say I can recollect myself discussing that with the Chief Operating Officer or Chief Executive Officer, but I think it's very likely, I know it to be the case, that feedback will go direct from primary drafters back into the departments. The delay in producing legislation is perhaps unfairly sometimes attributed to Chambers, when in fact it's more of a reflection of the quality of instructions. It's no one's fault. It's just that we don't have the trained personnel. I mean, what we are referring to as policy officers are in truth probably officers who started off as secondary drafters in departments and probably haven't been trained to deliver a policy input.
Is it possible that to sort of fix in order to sort of find a satisfactory conclusion to that situation, that perhaps the training, would it be fair to say that the training is needed, and therefore then there perhaps maybe some conversation around providing training would be useful?
I would agree with that, and I can't help noticing that on occasion our drafters are invited to contribute policy, and it's not their function, and
I've been on both training courses.
so there you are. So your question was, is there room for some training? I think yes.
Okay. So just then going back to some of our questions around Wooler, which is always everybody's favourite conversation. So in July 2023, just for those that are listening, and also we'll see on the evidence session on the video, Tynwald debated a report by Stephen Wooler about your role, Mr. Attorney. Tynwald approved some of Wooler's recommendations, referred to others to Coman for further consideration, typically the ones that were more directly related to Parliament, the three branches. For today, we're going to concentrate on the ones which Tynwald approved, so the ones that are more operationally focused. Wooler recommendation 342, so the transfer of functions relating to mental health, children and young persons. So in your annual operating report on page 18, you say that a new database will be created to manage cases which will link the legal case management system. So this is what you were talking about earlier on. So when will that system be in place? You seem to sound like perhaps it might be imminent, Nicola.
It should be imminent, yes. We're hoping to go to contract award fairly shortly. The bid process closed on the 23rd of December 2024, so it was a very exciting time for us in Chambers to review the bids for suppliers, because our current system has been in place for 10 years, so it's fair to say we're all ready for the new system to come in. We hope to go to contract award in this quarter, and we have already constituted a project board across Chambers with some of our seniors, our support staff. As Mr. Attorney mentioned, we have a business change manager in post. We have our corporate services team, so that's headed up by our head of Crown. We've got our finance manager, lots of subject matter experts sat around that table, so we are hopeful of a successful implementation towards the back end of this year, but we'll have obviously all the usual training, user acceptance testing and so on to go through before it's fully fledged.
Okay. Thank you very much. And just moving on to the annual operating report, dated on September again, 24, page 18 again. You say that procurement for the legal case management, okay, so that was scheduled for summer 2024. So yeah, is that sort of
Yes, it was delayed slightly. We had, you can imagine there are lots of functional and non-functional requirements that we needed to take account of. What we also didn't want to do was replicate any of the problems and perhaps omissions from the procurement of the previous system, which, as I say, has been in place for 10 years. So we did spend more time. I would say the delay was contributed to because we spent more time than we thought we'd need on making sure that each of the division's functions were covered and the requirements were covered. So we ended up with quite a substantial requirements document. You'll appreciate that legal case management and workflow flowing from that we need for that system will be very different for Chrissy's prosecution cases, to our litigation cases if they're running an employment matter, and to our advisory matters. And then, as Mr Attorney mentioned, we also have statutory functions, so our mental health financial management and charities registration and regulation files are also very, very different in terms of the functional requirements. So we did spend a lot of time making sure that every single requirement was covered, because we want to get the best value for money from that system.
So this is likely to sort of reach into the charities registration regulation. I was going to ask about that a little bit later on, but I suppose that's probably worthwhile asking about now, the filing there.
Yeah, and looking at how current systems speak to each other. So at the moment, we've spoken before in this room about charities registration and trying to digitise some of the functions. So we're already looking at a back-end charity system that will speak to our new legal case management system, making that accessible and available to the public to check a charity's information rather than manually emailing us in. So we have, as an aside to the legal case management system, been working on various other functions across chambers to make sure that we're ready to move not only with the legal case management system but digitisation.
Thank you. Wooler recommendation 345, Lexcel accreditation. So what process has there been with this? What's happened?
So we started the process with a STEP student who joined us last year. He was a very, very good STEP student and in fact won his year. I must give him an honourable mention. His cohort for that year for the work that he'd done for us and his subsequent presentation. And he was able to prepare for us a prioritised action plan. That prioritised action plan has been reviewed in our Crown team, and so we have a number of actions, but I would say that at the moment resource has to necessarily be diverted to the implementation of the legal case management system. So whilst we are making progress towards accreditation, we are not doing so formally as part of a Lexcel project. We have paused that so that we can do legal case management. I did have a look though at our action plan, because there are a number of actions we've taken that do go towards our Lexcel accreditation. So there are a number of examples. So I spoke before about the completion of our branding project and making sure we had a house style and templates. We have a new version control procedure. We've reviewed our risk register. We've done a full review of our policy register, and we now have our policies and procedures on a staff hub and an intranet site, so it's accessible to all. We've mentioned the litigation team as part of the right review has undergone a restructure, and as part of that we've prepared a litigation manual which has conflicts and conflict procedure and so on. So there are a number of actions we've taken across chambers anyway as part of our business as usual or in response to one of our reviews that go towards Lexcel. So luckily for us, we were able to tick more than one box. So we have managed to keep it ticking over is what I would describe it, but necessarily paused whilst we put our resources into the legal case management system, which has to be our priority for this year.
How far are you from getting that accreditation, do you think?
I think estimates would be 2 to 5 years. I think thinking that we would be able to do it within 6 to 12 months as a side of a desk project would be naive when I look at the amount of work. But I say that only in terms of formal accreditation. That is not to say that a lot of the work isn't already being done across chambers somehow. So some of it relates to business continuity, making sure we have new starters and leavers properly inducted and so on. We have exit interviews. We've had incredibly good feedback on our induction process in chambers. We do spend a lot of time making sure that new starters are inducted correctly. They meet all of the senior leaders in their first week. I'm sure it's a great dive in at the deep end for them. So we are carrying out that work all of the time, but that accreditation piece will need to necessarily come later. So my best estimate would be hopefully 2, but I wouldn't be surprised if it then stretches, because one thing leads to another with these things.
Yeah. Okay, thank you. Annual reporting. Are there any plans to lay the annual operating report before Tynwald?
Not at the moment, but there's no objection to Mr. Wooler's proposal. That should be, I think he suggested, a statutory requirement that we should do so each year. I've given an assurance to the Minister for Home Affairs that, at least on my watch, that we will continue producing it annually. And as I say, there's no objection to establishing that as a statutory requirement, but continue we will.
Perhaps if you have another statute law revision bill, you might put it there, Mr. Attorney General.
Yes.
Wooler recommendation 1034, the separation of the prosecution function. How has that gone, Chrissy?
We've gone about as far as we can pending the legislation now, I think. So physically, we have been cloistered, as it were, from the rest of Chambers. So we're up there on the third floor with the asset recovery team and international cooperation. We have a project manager who has attended to scoping the business as usual functions that we will need to effectively separate. Obviously, there will still be some shared services in terms of technology. It will be pointless to have a separate system for such a small team, and the technology exists so that we can Chinese wall our data, as it were, so we can continue to process that in accordance with the Law Enforcement Directive. There wouldn't be an issue with that. The necessary restructuring has taken place. We now have a separate financial crime unit that's ring-fenced solely for that purpose. And I think looking at the figures moving forward, we could well end up, from within existing resource, having a separate RASO unit. And I know that's something that we'll come on to talk about later. But certainly the new legislation has focused us in that direction. So we have done as much as we can do. I think we've got the policy document now from DHA, and it's simply a question of drafting, I think.
Right, that's very exciting stuff. So you've already recruited a project manager then. That's fantastic.
Yes. I'm hoping there'll be a draft bill in the summer.
Yes.
There will. Is that already in the plan, is it, in the legislative plan? Mind you, Mr. Attorney, I believe it's been some time since the legislation subcommittee has met.
You're on it. It has been some time since it met, but I am aware that there are conversations, if you like, going on between Coman and the departments, and the next iteration of the island plan, I think, is in March 24. So the departments have been asked to ensure that their entries in the legislative programme as recorded in the island plan are up to date insofar as any new pieces of legislation which are to be added, and equally any existing objectives which can no longer be achieved are to be identified. So the pausing of the legislative subcommittee has not brought to an end that reviewing process, fortunately.
So in the same report, it's intended that the division will operate separately in a shadow form whilst that legislation is awaited. So what does this mean for you, Chrissy?
Effectively, I have drafted a superintendent's agreement, which we're still in the process of developing, but effectively what it will mean is that there will be a strategic management board which will say these are your strategic objectives for the next 3 to 5 years. Normally 3 years would be an appropriate period of time within which to establish effectiveness. And it could well be that the priorities at that time would be a reduction in financial crime, a reduction in violence against women and girls, enhanced services in and around the RASO piece. So those would be the objectives, which as director I would then subsequently translate into operational objectives, and they would then again follow into the performance reviews for the officers to carry out, because their functions should always be aligned with the strategic objectives that sit at the head of the division.
And just
can we ask the Director of Prosecutions to, I think you used an acronym a couple of times, which
yes.
I didn't understand. Did you say RASO?
Rape and serious sexual offending.
Thank you.
Right. Thank you very much. It's just useful for
Yes.
in terms it's more accessible and people may be watching on the video as well. The separation, and I'm sorry if you've already said this, and I'm just asking the question again. I do apologise, but I can't remember whether you had said it or not. But the separation, when would that be complete? What do you think?
When the
I just want to jump in. Actually, a reference to separation is probably not quite accurate. It's more of a distancing of the relationship between the Crown Office. And you're right, it is a further distancing. Because even at the moment, and it has been the case since I've been in post, that in reality, the director operates independently already, except insofar as there may be some infrequent referrals to me by her. So we have almost an operational independence in existence at the moment. And if anything, we'll be building upon that. Mr. Wooler's recommendation is that there should be ultimate superintendents remaining with the Crown Offices, and Chrissy referred to a draft superintendent's agreement, which will spell out those infrequent occasions when Crown Officer involvement is required. I am a bit touchy about separation because it's not a separation, but it is a distancing, although we are virtually there at the moment. And that is how it should be in our jurisdiction, where I have a hat in advising executive government as well. So that distancing is a worthwhile suggestion from Mr. Wooler, if I may respectfully say so.
Yeah, thank you, I appreciate that. Thanks very much. Sorry. No, go ahead.
Sarah, may I just ask a related question? I think the point was made earlier on about quality of instructions in getting legislation moving, and it just sparked a thought in my mind. Who is in fact instructing the drafter in relation to this prosecution distancing initiative?
So we've received from the DHA a policy paper setting out what you might call drafting instructions, and that, informed as it is by Mr. Wooler's report, is the genesis of what will be the draft bill. But I fully expect that will be going to consultation as well.
Okay. And is that policy paper considerable enough to provide you with the instructions that you need, therefore, or the drafters will need for
well,
such
there'll be
a piece?
ongoing work, but certainly it's the drafter's view that there is enough there, as I say, for a draft bill to be produced by the summer.
Right. Okay. Thank you. I believe that sort of that leads us neatly on to the drafting of primary legislation element of this particular session. So I'll leave that to you.
A question for Mr. Attorney General, and I suspect I know the answer to this, but you might surprise me. Is the Legislative Drafting Division sufficiently resourced?
What do you think the answer is?
I think you're going to say no.
It depends is the answer, and I think this came up 2 years ago when we were last together. It depends on what the workload is, to put it like that. If I may.
Does that vary dramatically during the course of the year?
It will do. So we're expecting, as is not uncommon in the life of any administration, for the instructions to start coming thicker and faster than has been the case since 2021. So one of the things we've been able to achieve as a result of those instructions perhaps not being as plentiful as one would have liked, is that we've been able to devote far more time than has traditionally been the case in drafting private members' bills. There's been an unusually high number, and a lot of these bills, for which Madam Chair is responsible for at least one, are complex bills. And I think the Tynwald Companion records that what we try to offer is 3 days drafting a month, but it's been very greatly in excess of that in looking after the Reproductive Rights Bill, the Assisted Dying Bill, and others. So drafting resource has, in this administration, hitherto been sufficient. But it may not always be so. We know that the hydrocarbons projects are going to place certain demands. That's probably a little unfair of me to say, because there's already an external resource in place for that. But the 12 months hence, so it may well be that I would answer your question differently to the way I'm answering it now.
Well, that leads naturally on to the next question. How is it working with the balanced work from, on one hand, the government and on the other hand, private members?
It is a balance. The primary delivery is in servicing government legislation, but that private members' bills have never been excluded. It's just that we try to manage the time in the way I've explained. There are a couple of private members' bills which are still in the early course of development, so we haven't been able to progress those perhaps by as much as one would have liked, but that's no surprise to me given what I've said about those bills which have progressed, as well as the government programme, which again I've probably been unfair there too. It's not that the government programme hasn't produced demands of its own. There's been a fair number of bills going through, and I think there's I think we just looked at this before coming in. I think there's 12 in the branches at the moment. We have sufficient drafting resource as things stand to meet both government and private members' bills, I believe.
Okay.
Would it be fair to say that towards the back end of an administration there always seems to be a great flux of primary bills that seem to come forward from government and therefore take up an awful lot of resource in chambers?
Yeah, experience would suggest that to be the case. Remember what I said a few moments ago about departments feeding into the most recent iteration of the island plan, trying to be realistic about what can be achieved for them, and they need to balance between what is realistically achievable and what is not. So we should be signalling where legislation is not practically feasible before the end of the administration. But the other side of the coin is that on occasion a department will identify as a matter of some urgency some legislation which needs to come through even if it hasn't been on the programme. So March 24 Island Plan will tell you a little more.
Would you say it's quite useful for drafters, for everybody actually involved, to have one comprehensive list of all legislation that needs to be developed or may be expected to be developed in an administration?
I mean, that is what I think the Island Plan tried to achieve, but straight away, I mean, a wish list is one thing. Servicing the policy input is another, and straight away you can see perhaps that there's a difference between what one would like and what one is able to deliver.
And between, say, for example, around October and now, there have been a couple of departmental plans that have come forward. So say, for example, the Department for Home Affairs has provided us with a plan for its legislative work, sits at the sort of middle to back of the department plan, and it has a list of legislation that it would like to be able to bring forward. A number of those that sit between 25 and 26, quite a significant number of those. So is there advice, I suppose, from Chambers on managing expectations when there is that sort of void, I suppose, in terms of like the Council of Ministers Legislative Subcommittee? Does Chambers advise Council of Ministers on whether or not there is sufficient resource to be able to achieve the things that are being suggested to the public that they are able to resource?
So the conversation we've had over the last 5 minutes is not the first time I've had such a conversation, and so I believe ministers are aware of what is required to progress. I mentioned that we're looking again at the Island Plan, or the departments are. And it's very difficult, isn't it, to recognise that a piece of legislation which has been long anticipated, in fact, is not going to be achievable. And it's a bitter pill to swallow sometimes, perhaps, to remove that from the legislation programme, almost as an acceptance that it's not going to happen no matter the wish for it to happen. So has that message sunk home with all departments? Perhaps not, or to a greater degree with some than others.
I think perhaps in some ways it's difficult to kind of like gather as to when certain pieces of legislation may come forward that are within some of these department plans as well. Say, for example, the Cabinet Office plan that's out at the moment talks about government reform legislation that doesn't actually sit within its legislative programme in the same plan. So you end up talking about something that is a priority but doesn't sit within the legislation plan. So therefore it becomes the understanding of where legislation is, where it flows from, when it's actually going to come forward. If you're a member of the public, say for example, and you pick up some of these plans, it's perhaps not necessarily giving you a good understanding of that, what you're going to see from said administration.
It's not an unfair comment you make. It's probably something which should be managed, communicated by the legislation subcommittee. I probably wouldn't want to say much more than that, but.
Can we just discuss the process of drafting amendments to bills during the passage through the branches? Have you ever supported the drafters in saying to a member of Tynwald either no or even just not yet?
So have I supported them in saying no? I don't believe I have. But this is an issue which is the topic of some discussion in Chambers, because it's not infrequently the case, and it has been the case just recently, whereby instructions for amendments in a government bill will probably more often than not come from backbenchers and come fairly late in the day. So that I'm aware of cases just recently where instructions for amendments which need to be tabled by a Tuesday are coming in on a Friday, or even on one occasion on a Monday. And that might be manageable because while drafters are doing that, they're not doing something else. But when you're getting instructions, as was the case just recently, for 14 or 15 amendments with 1 day's notice, it becomes very hard. It's not a case of us saying no, but sometimes it's not feasible. I think that until recently, when there was another example, there has only previously been one example in my time in Chambers when we weren't able to produce an amendment within time.
Okay.
And I do sometimes think that perhaps it's something I should raise with the management committee as to whether there should be some sort of process for the instructing of amendments, which would allow a little bit more time than that.
Are you aware of a problem where drafters are called on to draft amendments late at night, for example, out of hours?
Are they told not to draft late at night?
No, I'm saying, is that a problem at the moment where drafters are asked?
So I'm aware that does on occasion. It is a reflection of what I've just said, that instructions may come with 1 or 2 days,
Yeah.
and one never likes not to be able to service our politicians, but that will explain why it's been that time of day that responses have been received, because the alternative is no, we can't do it.
Yeah. But does that prejudice the quality of the work done? You know, if you're asked at the last minute to produce something, is haste sometimes the enemy of quality?
Well, I don't want to say I'm aware of any drafting or amendments being drafted which are poorer in quality for want of not being prepared in greater time, but you may think that legislation drafted in haste is probably not as good as legislation drafted with more time.
Yeah. Okay. Chair.
Might it be sensible, because obviously politicians, parliamentarians on this side of the fence, they need to manage their time well as well, and they need to do their job well as well in terms of being legislators and sort of, knowing what is and what isn't possible, managing their own expectations, as it were. Might it be sensible perhaps to provide more comprehensive level of training when at the start of an administration, or perhaps when new MLCs come into role?
Well, the answer has to be yes, doesn't it? But that training is provided by our drafters at the beginning of each administration. But perhaps more helpfully, one thinks, would be for politicians to not leave thinking about amendments until the week before they're going to debate them. There are opportunities at consultation, at members' briefings, for them to focus their thoughts at that time. I can see that sometimes one's attention is not focused until you see in black and white what the proposed legislative provision is. But I'm bound to say that I do think that legislating backbenchers have opportunities far sooner than the few days before a session to propose amendments.
Just to be fair, with backbenchers, they're not also government departments that perhaps ask for amendments to pieces of legislation as well?
Yes, there are, and that ought not to happen were the instructions of an appropriate quality at the time, you would think. I mean, everyone is trying their best, Madam Chair. It's difficult sometimes.
Thank you very much. So just moving on to the prosecution of sexual offences, which is a theme that we've provided the Attorney General Chambers with, and thank you very much, Chrissy, for coming along today. So your input here is invaluable.
You're very welcome.
What proportion of sexual offences which are reported to the prosecution division by the police end up being prosecuted?
It can vary from year to year. I would say normally certainly half. Some years it is not as many as that, but certainly we are moving in the right direction. Looking at the police statistics, certainly in the last 12 months, they've gone from 34% to 62% of offences being finalised with a positive outcome. Because obviously with the introduction of new legislation, we have adopted a different operating model. Previously, we were labouring under some quite elderly legislation in terms of sexual offending, and certainly we have seen a significant increase in our work, because clearly a lot more things are an offence. There are more offences now that are effectively strict liability offences for children under the age of 13. So all of those things have come into play. We are receiving certainly more advice files, and that will only continue to grow, I suspect. So we are moving towards broadly adopting Operation Soteria principles, really, from the United Kingdom. All the prosecutors are RASO trained, rape and serious sexual offending trained. They have training with the Crown Prosecution Service, and we've also procured training in-house as well.
How has that changed then? So the RASO training, what does that bring?
What that brings is a completely different approach, because I think certainly many, many years ago, when I sort of first started off prosecuting, a review of a case would sort of centre around, well, why didn't she shout? Why didn't she do this? And why didn't she do that? It was very victim focused, really, but entirely in the wrong way, in my respectful view. We are a much more defendant focused operating model now, in terms of myths and stereotypes are rejected right the way down the line. When we look at investigations, it's not appropriate. No one person will react in a certain way. All the prosecutors have had trauma-related training as well, in terms of the effect of trauma on memory. So we work with the police from a very early stage to build very robust cases in order to bring them forward for prosecution, and we've done so very successfully recently, as you may well have seen. So we are looking at actively building cases, as opposed to looking at cases with a critical view and saying, oh, we can't do this because of that.
Right, okay. And has that been from the point where the sexual offences and obscene publications legislation came in, or was that sort of beforehand? Did you start sort of changing practices before that point?
Yes, because obviously I had come from a very different regime from the Crown Prosecution Service in the UK, and they've been very good at providing our training. They don't just provide us with sexual offences training. We have access to their training programme, so lots of the prosecutors will be having ongoing continuing professional development from that source as well. And unfortunately, the figures that I have only go back to 2019, because when I came in, that was a very important part of what I was asked to do in terms of building that statistical picture, because until you know where you're going wrong, you can't turn things around and move in a different direction. So that has all been part of the work. We have worked very closely with the police. So since COVID, really, that was the start of a very close relationship in terms of charging and providing charging advice to the police, which is all done in writing now. Even for the out of hours work that we do, they'll receive a written advice.
Is there also sort of some advice in terms of the necessary amount of evidence that's needed in order to be able to bring a prosecution?
Oh, absolutely. So we have a number of clinics that run in the police station. So we have a short bail date clinic on a Tuesday. We have normal other clinics. We have a special sexual offence and domestic abuse clinic on a Thursday afternoon, where officers will come to see us, often at the very beginning of an investigation, to say, how can we make this better? And we will go through and we will look at different lines of inquiry, different witnesses that can be spoken to. As I say, we're looking at building a case proactively.
How many of these cases that are coming through sort of look like, I mean, obviously we had the domestic abuse legislation that came in at a similar time. I'd imagine that the training for that would also then have taken place. Was that, so how many of these cases are domestic partner crime? Rape cases and sexual offence cases?
Unfortunately, we don't keep that level of data within Chambers in terms of the cases that we prosecute. Obviously, the police have Connect, and so they're able to give us a bit of a different picture. So what I can say to you, I think it was for year 23-24, the police received 41 initial reports of rape. 39% of those were not furthered because it wasn't supported by the complainant. So you can see that where the dropout rate is there. 8 of the rapes reported were committed historically. 19% of rapes were finalised with a positive outcome. 42 were finalised as not detected. The majority of the investigations couldn't be furthered due to a lack of evidence, conflicting accounts provided. 5 were still under investigation at the conclusion of that year.
Right. The support that's provided to police in terms of the evidence that's needed, what types of evidence would meet the threshold?
It's very fact specific. It varies from case to case. What people normally say to me is, "Oh, how do you get corroboration?" We don't. Generally speaking, people who commit sexual offences don't do so with an audience. So we focus on the credibility of the allegation first, and I think there may have been occasions where the credibility of the complainant was perhaps first assessed, and in my view that's the wrong way of going about it. So we look, is that allegation credible? If it is, we then move on to look at the other working pieces of the offence. If it is a stranger rape or a sexual offence that takes place in public, we will set the usual inquiries in train in relation to CCTV. Forensic evidence. If the case comes down to a question of consent, it is simply the complainant before the jury saying, I said no.
So in terms of stranger rape, you're not being able to sort of like break down some of the figures that perhaps prosecutions have, but in terms of stranger rape, you must have an idea of how often that might happen by comparison to other forms of rape.
Incredibly rare.
Incredibly rare.
Yeah.
So a lot of these will be with people that are known.
Yes.
So yeah, without going too far down that road. In terms of the police training for what might meet a prosecution's evidential, and also in actually speaking to victims, speaking to witnesses, speaking to defendants, speaking to all of the different individuals that they may come in contact with in relation to one case, how are they trained and advised on what that looks like in meeting that evidential within the prosecution code?
We have had a huge input into the training for the new legislation. So we procured a piece of work from the specialist who has now joined us in Chambers as a prosecutor. We procured a piece of work that was a 2-day training course that wasn't for the faint-hearted. So in that room we had the prosecutors, we had the specialist officers from the police, we had staff from the sexual assault referral centre. We had anybody there who we thought would benefit from that training. So that was 2 days of a course in and around what the offences were, how we could go about proving them, what different types of evidence that they might want to look for. And obviously that door is always open. We're only ever a phone call away. So that training was really comprehensive, and it continues.
How does that relationship work with the Sexual Assault Referral Centre? Have you seen things get an awful lot better? Because obviously there was what I would describe as a far more than a blip back in 2017-18, where it wasn't available actually on the Isle of Man. A lot of people had to travel across. How has that improved? How have you sort of seen things improve in terms of being able to have the evidence that's needed and also in being able to prosecute cases?
In terms of this particular subject matter, we have a very joined up piece, so we are in touch with staff at the Sexual Assault Referral Centre. That it's very much an ongoing dialogue between everyone, really. And what the figures don't show you here is that there can be self-referrals. So someone could go into the SARC to receive treatment or to receive advice. Their details will be kept, but obviously that confidence can't be betrayed, and so there will be certainly offences that aren't reported by the police and aren't documented by us because they are the subject of self-referral. But I think the SARC have, just currently had a new counsellor appointed, so we are going to be meeting with her at some point this week. Hopefully the ISVAs, and I would like to see an IDVA as well, because as a former foot soldier, when you're in the witness waiting room, the difference sometimes between whether a prosecution takes place depends on whether you can actually get that witness there. And I can't stress to you enough how important ISVAs and IDVAs, just for the benefit, the independent advisors in both subject matters, both sexual violence and domestic violence, critical. Really for victims of these offences to be able to have that support. But we are looking at remodelling the way we deal with witnesses as well, to use more of the facilities with victim support to give victims a one-stop shop. So they will receive their warning from them, they will be supported by them, they will have contact from them, and hopefully they will be able to give their evidence over the video link from the new Sexual Assault Referral Centre when it's up and running.
Where are we in terms of what good looks like in treating victims and witnesses in that sort of move through the legal system and into the courtroom?
I don't think it's any secret that I've been quite vocal about special measures. And I would hope to see, I think we're going to be seeing in one of the bills coming forward, provisions for pre-recorded cross-examination. We're now using the video link more than we ever have before, but unfortunately, because there is that proximity between the law dictates the offence has to have happened recently to be able to rely on a video recording. For some of the historical offences, we're still looking at taking statements and people giving live evidence, which is something that I would like to see change.
And what is the prosecution division doing in order to try and improve that likelihood of success once you take on a prosecution case, moving it through?
It's a question of continual review and making the appropriate applications. When there is an opportunity to admit hearsay, we will always take it. When there's bad character evidence, we will always make that application. We will do anything within our power to make that case the best it can be by the time it gets before the court.
How long typically will some of these cases take, or is there no one typical amount of time?
If there is, for instance, if it was a stranger rape and we managed to detain a suspect very quickly, we'd be looking to possibly charge on the threshold test, which is very different from the full code test. It would depend on a number of factors. So strictly speaking, the sooner a case is charged, the quicker it makes its way through the system. But there are a number of matters before general jail at the moment. Now, I would probably say it could be anything up to a year before you could get a final trial date.
Would you say that that's a good period of time? Would you say that perhaps there's room for improvement in how long it takes?
Obviously, I'm used to an existence where there are custody time limits. So in the United Kingdom, you have to get somebody to a trial date. I think it's within 182 days. So the timescales are much smaller. You can't hold people indefinitely. The custody time limits will apply. So I'm sure that once the Justice Reform Amendments come in, and we do have that direct transfer to the Court of General Jail Delivery, that things will become quicker.
And you mentioned the threshold test, and just for the sake of those that are listening, yes, and also in the gallery, could you just explain that a little bit more, how the difference between that and the test for the prosecution code?
So when there is a situation where a defendant, the police are seeking to keep a suspect in custody, we would assess that as prosecutors, and if there's a decent prospect that we can make an application, if the grounds exist for that person to be remanded in custody and the offence is a serious one, we would look excuse me, to the threshold test, and there are 5 parts to that test, but broadly speaking what it means is that is there reasonable suspicion that that person has committed the offence? And if the answer to that question is yes, we would then look at what further inquiries could possibly progress the case. We would expect the police to commit to a time frame within which to complete those further inquiries, and we would charge the case on the basis that we would normally be able to apply the full code test within a 3 to 4 week period once the further evidence had been gathered. But at that time, the risk analysis means that it's appropriate to apply the lesser test at that stage.
Right, okay, thank you. I'm just going on to the prosecution code. That's based on the UK code, am I right?
It's based on it's quite outdated actually. I'm currently working on a newer version.
Can you just explain a little bit more about that newer version and how did you do a benchmarking exercise of what good looks like? How's that come about?
A prosecution code test will always essentially be the same thing. Is there a realistic prospect of conviction? And I don't think we can ever resile from that. I know there have been discussions about whether that's the right place for the code test to be, but we have to look at the words ringing in the ears of the jury when they're sent out of the room, and that is, you have to be satisfied and you have to be sure that the defendant is guilty, and that's a very, very high bar, and rightly so. So we can't approach a case from the basis that we think he might have done it, so we'll just give this a go. We have to have a very firm foundation, but certainly the new code test will feature that, but it will also directly remove the notion that myths or stereotypes, particularly in relation to sexual offending, are appropriate at any point in the application of the code test.
And how long will it take before you're happy with the?
I'm hoping that we're going to have a rebranding and rebirth as a shadow authority. So it will be the new code test. It will be the adoption of the superintendent's arrangements and the strategic direction of the prosecution service moving forward.
Right. Okay. That's very exciting. When was the last time it was reviewed?
It's long before me, actually. It was 2017, I think, or 2016. So it's long overdue.
Thank you. I have no more questions to ask, so I'm going to turn to... No?
May I?
Of course.
Out of curiosity as much as anything else, I assume that the evidence in these cases that we've been talking about is quite voluminous, and it may involve things like social media. Does that come into it, or maybe not? And text messaging between people?
Yes, it depends on the type of case. So if it's a stranger case, clearly previous contact in social media simply isn't going to be an issue. But if it's an offence that's alleged to have taken place in the context of a relationship or a marriage or whatever, we will look at social media and we will look at other types of information as well.
The reason for asking really is not just curiosity, but I'm guessing that your legal case management system is going to be designed to handle that sort of thing in a more efficient way than the previous systems.
I think I've bored everybody to tears with my observations about relying on paper.
Oh, I've missed this.
Yeah.
So please bore me.
I am very digitally minded, so I would like to see us move to a system where we're not. So in a case with, say, 6 defendants, we're printing out boxes of stuff to serve. So I would like to see us move to a more digital based system. So with that in mind, part of my requirements were huge amounts of storage on the individual case files, so that things like telephony reports, I mean, if it's a case where there's been a lot of text messages, I mean, you could be looking at thousands of pages. We do have the facility to search those as PDF documents now to get to what we need to see. But yeah, there's certainly room for improvement there.
But you're building a system which does what you need,
Yes.
and what they need in other bits. The Attorney General's chambers, mental health, and God knows what. Does your system talk to the courts, or is that a daft question?
Well, obviously, I would like it to. I don't think we need to reinvent. We don't need to particularly reinvent the wheel there, because all we need to be able to do is serve on the court information in a digital form that they will be able to store on whatever their system is. As long as the court is adapted and it's ready for the what we call an EPE court, electronic presentation of evidence court, as long as that exists, we'll be able to rub along together quite nicely.
Would you suggest that perhaps that exists at the moment, or that they may have some way to go in order to be?
I don't know where the court procurement is up to yet. I do know that it's definitely still a work in progress, but I do think they're hoping to have an implementation date soon.
Yeah. I think that the clerk here was reading my mind almost, as I'd written it down just as you were speaking just then before he asked the question. That's something I think that when I was first elected, I remember going down to go and see the police, and they were pulling trying to explain to me how much information it took to be able to sort of move a case forward, and there were boxes on boxes on boxes that could just fill a room with one case. So things have moved along an awful lot, but one would suggest that perhaps, I mean, please do tell me if I'm completely wrong, but that Connect, in this case management system, and the courts, that it would all need to be communicating with each other in the right ways, but with the right conflicts removed, if you get what I mean.
If you really want me to bore you about API interfaces and two-way interfaces, I can do. But we're hoping that the case management system that we procure will have a two-way interface, a TWIF, so that cases come across from the police to us and rest on our system, and then we will task that out for review. And we will also have, in terms of disclosure, we recently went to the CPS disclosure conference about third-party material, because that sometimes features in cases as well, and how most appropriately to deal with that kind of material as well, and to be able to search that. So there is within the police a system where you can search for disclosure and things like that, and we are looking at using disclosure management documents, but that's a whole different topic. I'd be quite happy to come back and talk to you about it, but that's a whole different topic.
Yeah, it sounds like very exciting stuff, and to see the sort of legal system becoming far more digital and less paper-based, I think, is probably something that everybody can celebrate.
Yes.
Mr. Attorney, is there anything else that you would like to add that hasn't been spoken about? I know that you were very excited to talk about Mr. Richard Wright and also Lord Garnier.
No, the short answer is no. I have said everything I wanted to about Mr. Richard Wright and Lord Garnier at the respective debates. I am able to talk about it, but it's pretty much as you understand the position to be. Insofar as recommendations have been made as to the operational performance of chambers, we have, if not already implemented, are in the process of implementing all of those respective recommendations.
Right, and how far do you have to go with each one, do you think?
So Wooler, for our operational recommendations, I think we're there, actually, and I stand to be corrected by Nicola, but I think you could say the same about Mr. Richard Wright's report as well. Do you remember there were some recommendations about the way in which we manage disclosure? I mean, I ought to just record that one of his recommendations was that we should increase our employment law resource in Chambers, and happily Treasury supported us in that, and we have recruited 2 new positions and a junior lawyer starting, I think, this very week, which will tick the box nicely, and it has allowed additional services. So I have a mind going out into departments and training them about their own disclosure responsibilities. And in fact, I think there was a Tynwald Prison members presentation just last week from one of our employment lawyers. So, and I mean, the other important news was that we've placed one of our senior employment lawyers within Manx Care at the moment. So that which was the origin of a fair few employment cases, and so that seems to be working well. But no, I've got nothing to draw to your attention by way of any outstanding recommendations which we have failed to implement. I mean, there are recommendations which await further Tynwald input, I think,
Yes.
but they aren't operationally relevant to Chambers.
And just as one final question, and while I have the opportunity to ask, are there any gaps in expertise that currently exist in Chambers at the moment that perhaps you'd like to fill?
So we spoke last time about the circumstances in which departments, boards, officers will go external for their legal advice, and one of the usual grounds to doing that is because of a lack of expertise, subject matter expertise in Chambers. And so the answer to your question is that yes, there are areas where we do lack specific subject matter expertise, and I mentioned the hydrocarbon projects as perhaps no surprise that we needed some specialists in that area. And I think that there will always be examples of departments needing to go out for want of particular expertise in Chambers. I mean, you know, in spite of what I often hear referred to as the largest legal practice in the Isle of Man, the fact of the matter is that many of our lawyers, and I'm one of them, are probably best described as general practitioners rather than subject matter experts. And you can imagine, in looking after governments, legal requirements, on more than one occasion you do need that particular expertise.
Yeah. Well, thank you very much. I really appreciate your time, Chrissy, Nicola, and also Mr. Attorney General. I'd now like to draw this session to a close, and the committee will sit in private. Thank you for your time.
Thank you.